Hi, my name is David Grix, and I'm Vice President of Fishing for Freedom. Our organization represents over 2,500 citizens that have never experienced constitutional due process under the rule of the Florida Fish and Wildlife Conservation Commission. In fact, our lack of constitutional due process and equal protection of the law goes back to 1995 and 1996. In 1995 to 96, the MFC held hearings to create rules for nets under Article 10, Section 16. In July of 1996, the MFC promulgated the 2-inch mesh rule without the constitutional authority to do so. Ronald Fred Crum filed an administrative appeal in October of 1996 and then filed for summary judgment. His first one was in November 1996, the second one in July of 1997, and the third one in July of 1997. The only standard of Florida Statute 370.025 used was the best information available, mainly consisting of testimony that turned out to be fraudulent. From the second summary judgment, count number 5, in case number 965868RP. Petitioner, that's Ronald Fred Crum, alleges that the respondent, the Marine Fisheries Commission, is not permitted by Chapter 120.54 1F of the Florida Statutes to promulgate proposed rules without legislative authority where the rules are not effective prior to the effective date of subsequent legislation. Petitioner alleges that Chapter 120.54 1F of the Florida Statutes allows agencies to initiate rulemaking only after specific legislation has been enacted, but when there is a delayed effective date. That is not the situation in the instant case. On April 6 of 1999, the first DCA returned their opinion of the case. And they said, on page 6, at the time the Florida Supreme Court decided the Department of Environmental Protection versus Millender, Florida, 1996, the MFC had no authority to promulgate rules implementing the Net Ban Amendment, or Article 10, Section 16. Although the MFC had certain specified authority to promulgate rules implementing other provisions of Chapter 370, the legislature had delegated no authority with particular regard to the restrictions and prohibitions set out in the Net Ban Amendment at the time Millender was decided. After the Millender decision, the legislature granted the MFC authority to promulgate rules implementing the restrictions and prohibitions of the Net Ban Amendment. Clearly, 96 came before 97, thus the MFC's rule is invalid on its face. Despite the MFC having no authority to promulgate the rule, the First District Court of Appeal inexplicably let the rule stand. And ever since then, we've been on the back of the bus. We are shocked that FWC's General Counsel James Antista hasn't told the Commission that the 2-inch mesh rule was never legally adopted and that the MFC's expert court testimony was proven to be false by FWC tests. From the 1996 handwritten interrogatories pertaining to Florida Statute 370.025, please identify any facts, documents, and reports you rely on as to the impact this proposed rule will have on the following: consumers, food stamp recipients, African American citizens who consume 78% of net caught fish, Hispanics, or inner city citizens. The MFC declared the interrogatories irrelevant, disregarding citizens' rights in Florida Statute 370.025.
The administrative proceeding was found that that net rule complied with Section 370.025.
Let's look further into 370.025. To provide optimum sustained benefits and use to all the people for the present and future. You be the judge. Do 2-inch mesh nets provide optimum sustained benefits? Listen to this.
It makes no economic sense to go out there with a 2-inch mesh net and do that to the juvenile fish.
Listen to what else the FWC's attorney admits about the FWC's 2-inch mesh net.
Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When they ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. 90% of the fish that were gilled.
That's what Mr. Maurer just
well,
said.
I'm not questioning his that. I mean, 90% of the fish that were gilled were juvenile.
The FWC's 2-inch mesh nets make no economic sense, unnecessarily killing and wasting over 90% of the resource. All saltwater fishery rules adopted by the Commission shall be consistent with the following standards: the best biological, sociological, economic, and other relevant information available. The MFC ignored conservation. The MFC ignored biological data. They obviously ignored sociological impact. And economically, 90% waste in any business is uneconomical. Because the MFC ignored 370.025, many aspects of our economy are still suffering, such as fish houses, box makers, truckers, restaurants, and more. Just so you understand MFC FWC logic, 8 years of forcing fishermen to unnecessarily kill and waste over 90% of the resource is
historically based, rational, and practical. The hearing officer in paragraph 55 of the order, back on the rule challenge, said, quote, "No dangerous level of unnecessary killing or waste will occur, and the rule will enhance the overall fish population recovery effect already in progress."
Here's more 370.025. Allows reasonable means and quantities of harvest consistent with maximum practical sustainable stock abundance. Obviously, nets that catch less than 10% marketable fish do not comply with Section C of 370.025. 370.025 goes on to state, measures shall assure proper quality control of marine resources that enter commerce. FWC tests prove that 98% of the fish caught in the 2-inch mesh nets are illegal for commerce. What does the FWC say about that?
Historically based, rational, and practical.
What world does he live in? Here's more 370.025. Other federal, state, and interstate commission fishery management plans should be considered when making rules. You can disregard that section too. Federal and other state standards mirror section 370.025. And finally, decisions shall be fair and equitable to all the people of this state. There's nothing fair and equitable about the 2-inch mesh rule, especially when you consider that minority consumers purchase 78% of the net caught fish. What about the sole purpose of the amendment?
The singular sole purpose of the amendment is to protect the resource from unnecessary and wasteful killing of the resource.
To the back of the bus, the sole purpose doesn't matter to the FWC staff. A staff that will ignore the Supreme Court will ignore anything relevant.
And it's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination. This demarcation between what is legal and what is not under Article 10, Section 16 is rational, it's not arbitrary and capricious, it will not hurt the resource.
When you get better data, and newer data, and as I understand, your client agreed with the appellant to go out and test these nets, and when the results appeared to be adverse to your client's position, then the tests were terminated. Is that a
That is not absolutely not what happened.
That is exactly what happened. For nearly a decade, the FWC staff have repeatedly lied to the public, courts, and legislature. Fishermen are sold a commercial license and forced to use a net that the FWC admits is absolutely useless. Listen.
It is not economically reasonable for a fisherman to go out there and whack the undersized fish. They're not going to do that.
But as FWC tests proved, undersized illegal fish are the only fish the FWC net catches.
If they're killing undersized fish and making it uneconomical for fishermen to use a 2-inch net, they can reconfigure their net. They can use smaller mesh size. As we say in our brief, in Texas, they limit them to 1 inch. Not 2 inch, but 1 inch.
Brilliant, Einstein. A smaller mesh equals smaller fish unnecessarily killed and wasted, and still no marketable fish.
Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable?
If the agency presents a rational basis for the rule on the record, then that's all they have to do.